Good afternoon, everyone. Today I have with me to my right Chief Theo Glover with the Park District Police Department, who is also chair of the Winnebago Boone County Integrity Task Force. To my left is Commander Chuck Davidson with the Winnebago Boone County Integrity Task Force. And to his left is Assistant Deputy State's Attorney Heather Cruz. Today I'm here to give you my findings regarding the officer's use of deadly force, that being Rockford Police Officer Dominic McNeese, which occurred on October 2nd, 2020, near the intersection of Harrison and Springfield Road and Illinois Route 2. First, I'd like to just indicate to you the process that takes place during these investigations. As with any criminal investigation, investigators are tasked with investigating the incident, following leads, developing materials to then bring to the state's attorney's office to determine whether evidence is sufficient to warrant the filing of criminal charges regarding anyone involved in a particular incident. In reviewing cases where an officer uses deadly force, I am mandated ethically to follow the laws of the state of Illinois and the laws established by the United States Supreme Court that determine when it is appropriate for an officer to use deadly force, and that is whether or not a death occurs. In this particular incident, it was a non-fatal use of deadly force, but nevertheless, this is the lens in which I am required to review the investigative materials, and this is the lens through which I view the investigative materials. First of all, I'd like to share with you a summary of the Illinois statute defining the use of force. And it reads in pertinent part, a person is justified in the use of force against another when and to the extent that he reasonably believes that such conduct is necessary to defend himself or another against such other's imminent use of unlawful force. However, he is justified in the use of force which is intended or likely to cause death or great bodily harm only if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or another, or the commission of a forcible felony. In addition, the state of Illinois defines a forcible felony as follows. Forcible felony means treason, first-degree murder, second-degree murder, predatory criminal sexual assault of a child, aggravated criminal sexual assault, robbery, burglary, residential burglary, aggravated arson, aggravated kidnapping, aggravated battery resulting in great bodily harm or permanent disability or disfigurement, and any other felony which involves the use or threat of physical force or violence against any individual. A United States Supreme Court decision in Tennessee versus Garner, where they were tasked with determining whether or not an officer's use of deadly force was appropriate, the Supreme Court said, where the officer has probable cause to believe that the suspect poses a threat of serious physical harm, either to the officer or to others, it is not constitutionally unreasonable to prevent escape by using deadly force. Thus, if the suspect threatens the officer with a weapon or there is probable cause to believe that he has committed a crime involving the infliction or threatened infliction of serious harm, deadly force may be used if necessary to prevent escape. In addition, in Graham versus Connor, the United States Supreme Court found that the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene, and its calculus must embody an allowance for the fact that police officers are often forced to make split-second decisions about the amount of force necessary in a particular situation. In reviewing the investigative materials that were brought to my office, I have found that Officer Dominique McNeese was legally justified in the use of deadly force that he used on October 2nd, 2020 that resulted in injuries to suspect Tyrus Jones. At the time that Officer McNeese discharged his weapon in the direction of Tyrus Jones, he had reason to believe that Tyrus Jones posed a threat to the community based upon 3 outstanding felony warrants for one for forcible felony that were outstanding for Mr. Jones's arrest. He was legally justified to use force he believes was necessary to prevent the escape. And in addition, based upon Officer McNeese's observations of the defendant at the time, he reasonably believed that the defendant had a weapon, even though a weapon was not found. And again, I will remind you of what the U.S. Supreme Court said in Connor. We have to be mindful that often officers are called upon to make split-second decisions. In addition, at the time that Officer McNeese discharged his weapon, he also was aware that suspect Tyrus Jones was also being investigated for a murder offense that had occurred on September 26, 2020. That, as you know, has subsequently resulted in an indictment being filed, and as with any criminal charges, the defendant is presumed innocent until or unless proven guilty in a court of law. I have also found in reviewing the materials that Tyrus Jones on October 2nd, 2020 committed the offenses of attempt vehicular hijacking and aggravated fleeing to elude a police officer. And I'm also here to announce that a grand jury has returned an indictment against Tyrus Jones for those offenses. Attempt vehicular hijacking is a Class 2 felony that carries 3 to 7 years in the Illinois Department of Corrections. Aggravated attempt to elude a police officer is a Class 4 felony with a special sentencing range of 1 to 6 years in the Illinois Department of Corrections. These charges are merely allegations, and the defendant is presumed innocent until or unless found guilty or proven guilty in a court of law. I would also like to remind all of you that the standard, according to the American Bar Association, that a prosecutor should use in filing charges is only if the prosecutor reasonably believes that charges are supported by probable cause, and that evidence will be sufficient to support a conviction beyond a reasonable doubt. In part, this is the same standard that the state's attorney office uses in all criminal cases. I am called upon to evaluate the evidence, and if the evidence is there and I believe it is sufficient to sustain the charges beyond a reasonable doubt, charges are filed. In this case, I found that charges were warranted and the evidence was sufficient to file charges against Tyrus Jones. And again, Tyrus Jones is presumed innocent of those charges until or unless proven guilty in a court of law. I also understand that the public has a strong interest in facts surrounding an officer's use of deadly force, whether or not a death occurs. But as with any investigation that may lead to a criminal prosecution, a prosecutor and myself, a state's attorney, we are bound by the Illinois Rules of Professional Conduct, which means we cannot and are prohibited from disseminating any information that might create animus against the person who is charged or that might impact the fairness of the process, meaning the constitutional due process rights of the defendant. As you know, many times you may see defense attorneys making statements about pending cases, but you never see prosecutors doing that. We are held to a higher standard. We understand that we represent all the people. And representing all the people means that we represent the victims of violent crimes. We represent the community because we are tasked with keeping the community safe. But we also represent the defendants in that we have a duty to make sure that the defendant's constitutional rights are protected at every stage of the proceedings. And so information that you may want to know today, what I will tell you is that that information regarding this prosecution will be disclosed pursuant to our discovery rules to the defendant's attorney. Any other information that will be disclosed to the public, the proper forum is in a courtroom, whether it's in a pretrial motion, a bond hearing, but certainly the reason we have open and public hearings is because that's the venue in which the press is allowed to receive the details of any criminal investigation surrounding charges that are filed by the state's attorney's office. I would like to thank the Winnebago-Boone County Integrity Task Force for their diligent work on this case, following up on additional information, bringing that to me so that I could review that as well. Also want to thank the staff in my office who assisted with the review of the investigative materials. And again, want to thank the public and the community for their patience and giving me the time that I needed to review these matters to bring them to a resolution so that I could disclose my decision to all of you. At this time, I would ask Commander Davidson to come forward and make a few remarks, and after that, Chair Theo Glover will step forward.
Good evening. I would just like to take a moment to acknowledge the hard work and dedication by the detectives and from the agencies involved in the Winnebago-Boone County Integrity Task Force. The agencies included on this investigation include the Winnebago County Sheriff's Office, Boone County Sheriff's Office, Loves Park Police Department, and the Illinois State Police. I appreciate the collaboration between the agencies on this case and those 15+ detectives taking on additional roles in addition to their own regular duties and caseloads within their own jurisdiction. I just want to take the time to thank the sheriffs and the chiefs that allow their detectives to help with the investigation of these type of cases. So.
I would just like to echo what Commander Davidson's comments were. These investigations are never easy. However, under his leadership and the members of this task force, these guys go about doing what needs to be done to investigate these officer-involved shootings and ultimately turning that information over to the state's attorney's office for review. So I would like to echo his comments and thanking all the men and women of the task force for their hard work in this case.
I'll be happy to answer any questions that I am able to answer for you.
Now that this investigation is wrapped up, does that mean Officer McNeese is back on? I was under the impression he's on a paid leave of some type.
I will direct you to the Rockford Police Department for those details, but my understanding is that Officer McNeese has been back at work.
And you had mentioned that Officer McNeese knew of the potential of Jones being a suspect for that murder back on, knowing that on October 2nd. If you can kind of talk maybe why the charge came in November, that there was that, I guess, that delay or that separation between, you know, officers having that information and the charge, I guess, coming later.
Okay, so what I will say about that is that investigations take as long as they take. So whenever an investigation is completed, it's brought over to my office. And in these particular cases, murder investigations are personally reviewed by myself. I do have assistance with my criminal bureau supervisors, but I personally make all murder charging decisions. So when that information is brought over to me, obviously it's given priority, and that's when decisions are made.
And if there was, I guess, video that was reviewed in this process, is that something that will be at some point released to the public, or something that, I guess, can be at some point shared?
All of the investigative materials will be shared, as I indicated, to Mr. Jones's attorney. However, access by anyone else outside of receiving that information in the court will not be granted. And obviously, because that could impact Mr. Jones's right to receive a fair trial. So as in any case, for example, we do not release the details of information. We provide you with the information to support the charges, because the charges become public documents. But beyond that, we do not provide details regarding specific investigations or statements made by particular witnesses. And it's for that reason. The proper forum for that information is during the criminal court process in the courtroom.
And during one of the last court appearances, the attorney for Mr. Jones had raised allegations or concerns that he, in his eyes, saw that there were witnesses that were not included, I guess, in this report. I guess if you can speak to those allegations that he raised. Well,
again, you know, it's interesting that the attorney raised that to the press, but my office was never called to tell me that he had witnesses to this date. When I learned that information from the reporters, I did pass that on to Commander Davidson, and they did follow up on that information. So our goal is to follow up on any information that comes to our knowledge, but if we are not notified about it, then we can't follow up. But we did take a proactive role in seeking out the attorney after he made those statements to the press.
Just a couple days ago, you guys released warrants for Mr. Jones on some of that murder investigation. Is there any update that you could provide on that? Did he eventually get found and booked, or what happened there?
Yeah, yes, I can provide you some updated information. On these charges today, there was an additional warrant issued with $1 million bond. Mr. Jones was due in court before Judge Clifford today on unrelated charges. He did not appear, so there was an additional warrant issued for his failure to appear with $1 million bond. So he remains at large, so anyone who has information regarding the whereabouts of Tyrus Jones, please call Crime Stoppers or your local law enforcement agency.
And you've spoken to, you know, Officer McNeese kind of perceiving the threat, and that's, you know, what led to him, you know, opening fire. If you can kind of talk to maybe why he was the, I guess, the only officer on scene, or why others didn't open, I guess, fire? Was it, you know, due to proximity or his vantage point? I guess whatever you can share on that.
Well, the review centered around the officer that discharged their weapon. And obviously the investigation showed that he was the only officer that discharged his weapon. And based upon the review of the materials, I believe from his vantage point that he believed that Mr. Jones had a weapon when he had approached that vehicle, the motorist. And again, under the laws in the state of Illinois and the United States Supreme Court, Mr. Jones was already a fleeing felon. Mr. Jones had committed the offenses of aggravated attempt to elude police officer, and at that time it was reasonable for Officer McNeese to believe that Mr. Jones was attempting to commit another forcible felony, that being ag vehicular hijacking, even though no weapon was found in his hand. But based upon the circumstances, it was reasonable for the officer to believe that, and that is the standard that these cases are viewed under pursuant to U.S. Supreme Court laws and the laws of the state of Illinois. Any other questions? Thank you.